Distinguished guests, officials from Ashitiva Advocates, members of the board, executive committee, management and staff of Victoria Commercial Bank, good morning. It's a bit too late to say Happy New Year, but I hope all of you have had a great start to 2022. On behalf of Victoria Commercial Bank, I'd like to welcome you to the first of the many webinars we have planned for you this year. My name is Javed Khanna and I'm a relationship officer. So thank you for joining us today for this important webinar on land and title documentation. I will quickly just take you through the housekeeping guidelines. Ashitiva Advocates Ribin Onwari and Caroline Karugu will take us through the presentation on the topic of the day. Thereafter, we shall have a question and answer session. During the presentations, your cameras will be turned off and the mics will also be on mute. Though we encourage you to type in any of the questions that you have in the chat box so the speakers can then address them at the end of the presentation. If you wish to ask a question, you can still press the raise hand emoticon and we will be able to let you speak. We aim also to close the webinar within the stipulated 90 minutes, so we'll keep it short but informative. And now it's my pleasure to welcome a distinguished personality from Victoria Commercial Bank, our Business Development Director and a motivational guru, Mr. Manish Parmar, to officially open the webinar. Welcome, Mr. Manish.
Thank you. Thank you very much, Javed. Distinguished clients, well-wishers, fellow colleagues, members of Victoria Commercial Bank family, representatives of Ashitiva Advocates LLP, and friends, good morning. After hosting successful webinars on property market trends and wealth management last year, I'm happy to initiate this year's series of webinars, with the first one being on a crucial subject, that's lands and title digitization. It is common knowledge that digital revolution has taken over our day-to-day affairs. The pandemic accelerated the adoption of digital technology to various sectors, including education, healthcare, financial services, as well as corporate. Last year, the President in his Mashuja Day address spoke on the digitization of lands registry. The drive ever since has seen many property owners document their land and titles online. Still, there are several questions in the minds of many property owners. What happens to the title that one already holds? What is the process of digital documentation of the lands and titles? What if I'm a foreigner who owns land in Kenya? To address all these questions and more, we have today Ashitiva Advocates Ribin Onwari. My friend Ribin's permanent and unrelenting quest has made him an award-winning advocate of the High Court of Kenya. As partner, heading real estate and financial services at Ashitiva, his expertise broadly constitutes conveyance and real estate transactions, digitization of land transactions, conversion of titles and new sectional titles, just to name a few. Ribin is also part of the steering committee for the land reforms in Kenya. Joining Ribin is Caroline Karugu, an advocate of the High Court of Kenya who is recognized as a rising star by the Legal 500 under the real estate and construction category in 2018 and 2020, and as a senior associate to note by Legal 500 in 2019. On behalf of Victoria Commercial Bank, I welcome Ribin and Caroline.
Thank you very much, Mr. Manish, for that very generous introduction. I'll allow my colleague Caroline to say hi to the team, then I'll begin the presentation. Caroline, I think you're on mute.
Yes.
My apologies. Good morning, this Saturday morning. It is quite a pleasure to be joining you all, to be taking you through the digitization process that is happening at the Lands Office, as well as other changes that are coming your way. If you're a conveyancer, if you're involved in land transactions, this is definitely a webinar you don't want to miss. I have to say this is the first of this year, so we are happy to be to be with you this Saturday morning. Thank you very much.
Right. Yeah, if you're ready, you can then start the presentation.
All right, let me just share the presentation, then we begin. Thank you. Javed, are you able to see the presentation?
Yes, it's good.
Fantastic. So once more, to the valued clients of Victoria Commercial Bank, the board and executive management, the staff, good morning. As I've been introduced, my name is Ribin Ondwari. I'm a partner at Ashitiva Advocates. We'll be leading today the presentation on the land and documentation reform. Just before we begin the presentation, allow me to introduce our firm. So our firm, Ashitiva Advocates, was founded in 2020, precisely to raise the bar in legal services to enable you, valued clients, achieve your highest aspirations. Through continued opportunity to support some of you, we have built key strengths in the following key practice areas: real estate, banking and financial services, corporate and commercial, dispute resolution and litigation, and energy and infrastructure. We do have a dedicated team of 8 partners, 16 advocates, and a complement of 20 other professionals spread out through our 3 branches. We have the head office in Upper Hill, we have our Gigiri branch, and our Nakuru branch. Thank you very much for making us one of the top law firms in Kenya by allowing us to support you as you go for your highest aspirations. So as the webinar has been titled, really it's about the land and title documentation reform. But before we go into the reform, it's important to ask the question, why is the reform necessary? And in fact, our assertion is that this reform is necessary based on these following points. So as we all know and understand and actually appreciate, and I'm sure for the clients you appreciate this even more than I do, is that land is an important factor of livelihood and production. To get its maximum benefit, there is an urgent need to deal with the perennial land problems in Kenya with the aim of making land and title documentation, number 1, more secure, number 2, more reliable and transparent, number 3, accessible to all, number 4, simple, straightforward, and aligned within the modern times, and number 5, faster. As I understand, we have all in one way or another interacted with the land processes. With time, you realize that the physical way in which transactions are being carried out a majority of this time has really been overtaken by the times, so that there needs to be a more sophisticated way in which this documentation is stored and transacted to make them more secure. Again, the current physical documentation and processing is not as reliable and transparent in terms of the processes, as we'll see. In terms of also accessibility to the process, I mean, apart from the conveyance, as I'm not sure that the rest of the parties know where all these processes need to be carried out. The processes are also currently, before some alignment which has happened, the reform was not that simple, not that straightforward. And also there's an issue of time. And I'm sure everyone, especially the bank team, would appreciate this, and the conveyancers, because there's that need within which once you as the clients, you've lodged your applications with the bank, then you want the security documentation process to move as fast as possible, but then sometimes the process hasn't been as fast as needed to enable you benefit from your property based on the facilities that you're taking from the bank. So basically, these are the issues that are making this reform necessary, because the current way in which the property transactions were before the reform began was actually not sustainable. So in terms of the overview of the reform areas, there are 3 key reform aspects which are happening right now. The first one is the digitization process. Number 2 is the conversion of title documents. Number 3 is the section of properties. At this stage, I'll just briefly introduce these 3 aspects. Then I'll go into dealing in detail with section 1 and 2, which is digitization and conversion of title documents. Then my colleague Caroline Karugu will handle the aspect of section of properties. So what is digitization? Digitization really is the conversion of the documentation and transactions in land from the physical form in which they are to the digital form, to make them more secure under what is called the National Lands Information Management System, in short, NLIMS, and also easily accessible through the ArdhiSasa platform. We'll go into this in detail in a short while. Conversion of titles, as I'm sure you've heard all this, what it simply means is the conversion of title documentation from the current different regimes and structures into a consolidated structure under the Land Registrations Act. So not to worry, we'll go into discussing all this in detail so as to explain what all this means. But in terms of a general overview, these are the three key ongoing reforms in respect to land and title documentation, which we'd like to discuss today. So the first one, as I mentioned, is digitization. On April 27th last year, as Mr. Manish has mentioned, the president launched an online system. This system was actually the far end process of a process that began a bit earlier. So basically, converting land documentation and transaction into a digital form began a long time ago. And I'm sure a number of you have had the processes where a number of times they've been over and over of reports of the scanning and digitization of the processes and all the time. This has been happening for a very long time. So in essence, before the platform at VCB was launched, the documents were actually scanned and put in a digital form under the National Lands Information Management System. This system is actually covered in law, as we'll see shortly. So the National Lands Information Management System is basically a digital database containing the cleaned up data and records of land in a digital format. Now, this system is now accessed through the platform, which is called Artisasa. So as at this point, the key pointer to note is, if you haven't registered on the system, kindly register. So in terms of the key milestones that have happened, as I mentioned, this process began a long time ago. And this long time ago basically can be traced back to the 2010 Constitution, which is not so new now. That's why I've put it in quotes. But in 2010, it was new. That's basically where, in terms of the legal processes, this process can be traced back to. Because as at that point is when it was enacted as to how the new current framework in terms of the legal framework in land has to be amended. And because land is such an emotive issue in this country, it was given a whole new chapter with specific timelines and specific implementation as to what needed to happen. So one of the key aspects that was set out in the Constitution was the consolidation of the land laws, which now led to the repeal of the old laws and the enactment of the Land Act and the Land Registration Act. So in this Land Act, the Cabinet Secretary and the National Land Commission were empowered now to set up the National Land Information System, which is now what we've been referring to previously as the National Land Information Management System. Then a few years down the line, there was the digitization regulations. These were enacted to enable now the process of digitized transaction, because land, apart from being an emotive issue, is something which is heavily regulated, so that you cannot do anything which can affect the rights of land of people without having a clear provision in the law governing that process. So there's no way this process could have proceeded without these regulations. And for those who are been interacting with these processes, you'd remember these are those regulations which are a bit contentious, because there was an initial form which was actually gazetted, but they were rejected. Then within the process, there have been a number of challenges through all this. But as you can see, from 2010 to right now, all this process has been well thought out, and there's a legal framework which has been enacted to actually guide this process. So in 2021, as I mentioned, on April 27th, 2021, there was the launch of the National Land Information Management System, which is now accessed through a platform called Artisasa. Then subsequently, there's the phased implementation of this digitization process, beginning with the Nairobi Block Registry. Then once the Nairobi Block Registry has been properly set up and running, they'll go to the rest of the registries. So what's the implementation, what's the effect of this operationalization of the digitized system? So the key steps that one really has to take is the first one. You have to register your personal or corporate accounts through the link above. That link is artisasa.lands.go.ke. So essentially right now, if you have to access the National Land Information Management System, you have to use either your personal account if the property is registered in your individual name, or a corporate account if the property is registered in a company or any other corporate entity's name. So because I mentioned right now they're using the Nairobi Block Registry as a phasing, as a first phase to implement the system, all Nairobi Block properties, there's no manual processing. They have to be processed digitally. But then before any transaction is carried out, these properties have to be verified, because one of the key aspects, as we mentioned, the need for this reform is for that accessibility, the reliability, and to ensure that this data is properly secure. So before any property is transacted, the owner is supposed to upload their properties for verification. So the process of uploading the property is very straightforward. Once you've registered your account, you'll get to the landing page, which has an option for add your property. So the option of adding your property, you just add your details. Then once you've added your details, the registry at the back end will check the details to confirm that the details which you've uploaded tally with the data which they have on the back end. As I mentioned previously in the previous slide, there was a cleaner process of this documentation. So they have to verify that what you've provided and what they have, if they tally, that's when now the property is approved for transaction, to ensure that reliability and security of the information which is being processed through this system. If the property is not verified, you'll be required to attend to by supplying any additional information or clarification which is required. So only after the property is verified that you can transact on it. So if the property details at the registry, they have missing information or conflicting information, that property will not be transacted on until that has been sorted out. But once verification has been done, then you'll be allowed to proceed and transact on it. Aside from that, you can carry out searches and pay rent on your property on the system. The rest of the services that require professional, like advocates, surveyors, planners, can be initiated by these professionals. So right now, it has only been operationalized in the Nairobi Block Registry, but they are working to try and ensure that they deal with the teething issues which have been identified within this phased aspect as they work on taking the aspects to the rest of the country. So the key thing really is first, register your personal and corporate accounts. And if you own a property within the Nairobi block, it's best you start applying it for verification so that by the time you want to transact on that property, you'll have gone through the process of verification. So the second aspect, key reform, is the conversion of title documentation. As I explained, this one is simply the title documents and registered being converted from the current existing different regimes to a consolidated one. So I'll explain this in the next slide. I'm sure when you're dealing with land currently right now, it's very hard to tell what is even a certificate of title, because they are varied based on the law in which the title you're holding was generated. If your title was registered under the Registration of Title Act, you could have a grant, you could have a title deed, you could have a certificate of title, you could have a certificate of lease. If it was registered under the Registered Land Act, you could have a certificate of title, you could have a title deed. Key distinction has actually been, if it was registered under the Government Land Act, you could have a conveyance, indenture, assignment, and also in terms of the registers, you could hear things like folio and all that. So as you can see on that presentation slide, before the law was amended in 2012, there were key 5 statutory provisions that were governing the registration of land. And the effect of this was that there were different titles under these different regimes. In addition to the different titles, there were also different registries. So that's why sometimes you'd have some inconsistency as to what exactly you should expect as the end product once your document is being processed at the lands registry. In addition to that, you could also have some inconsistencies as to even the timelines, the requirements as to what is required to be documented, because all these registers required a different aspect. So, but notwithstanding the fact that these laws were amended in 2012, the actual conversion of the registers at the registry and the title documentation which parties are holding right now are still within the transition provisions of these laws. So, but what is happening now with the conversion process is to actually now take all this title documentation through a conversion process to ensure that you either have a certificate of title or a certificate of lease, and now this one consolidated law, the Land Registration Act 2012. Again, as I mentioned earlier, in terms of dealing with property rights, this is a very sensitive issue. It cannot just be dealt with without having a clear grounding in the law. Again, this now process of conversion is also something that is taking now, this being 2022, we're in the 12th year because it originated from the Constitution of Kenya 2010. And then in 2012, when the laws, the Land Act and the Land Registration Act was actually enacted, there was now that consolidation of the laws and repealing of the previous laws. But then the regulations itself to now govern that process properly were enacted in 2017. That's a whole almost 5 years from when the substantive law was enacted. So once that the regulations were enacted, there's some processes which commenced, which I'll explain in the next slide, which now led to the Gazette notices, which have been published from 2020 to 2021. So do you remember, most of the time from 2010 to 2017, there was not a lot of attention on these processes, but a lot of work was ongoing in the background. When actually a lot of attention was paid on these processes is when the first Gazette notices were gazetted in 2020. But there had been a lot of work that had been ongoing in terms of laying down the legal procedure to follow these processes. And as also I'll explain in the next slide, the processes which the registry then needed to take to ensure that they've done the work on the back end to enable this conversion of the titles to a consolidated sort of title. So the key steps really, the first one is establishment and maintenance of new registration units, sections and blocks. So basically what this means is that there are new registries which have been enacted. Once we finish this conversion process, they're going to be, like for example, if you've dealt with the Nairobi registry or you have transacted through your advocate in respect of the Nairobi registry, there are two types of registry in Nairobi. There's the Nairobi block registry, then there's a central registry. But once the conversion is done, there'll only be one registry because they going forward, there's no need of having those two separated registries. And again, when you go to the registry, there will be those different registers, the GLA register, the RLA register, the RTA. So once this one is actually done, we'll have one registry. And the way they've distributed the registries, if you look at the regulations, almost every county has its a single registry, with some which are sparsely populated, having at least more than one, so as to ensure that accessibility to people for these services. So once that was done, this was actually done in 2017 when the regulations were enacted. The ministry now commenced on the process of preparing a cadastral map. A cadastral map really is sort of an overview. It's a general map which shows the properties, how they've been registered, and the details of the sizes, the boundaries, and all that. It's more of a general picture of that registration. So they had to redo all this to ensure that the details which are made are correct. So once they finish the cadastral map, then they publish a conversion list. So conversion list is what now was published in 2020. So as you can see, they had to do all this work before they got to the point of publishing the conversion list. And right now, they've only published conversion lists in Nairobi as they keep on working to finish Nairobi before they go to the other counties. So once the conversion list has been published, these ones are being published in the Kenya Gazette. And I'm sure a number of you have seen those lists circulating containing people's properties and old numbers and the new numbers. So that's a conversion list. Then parties have 90 days so as to just check those properties. The key thing is at any point once the list has been published, it's important to just check and see if your property is there. If your property has been listed, the key thing you need to do is just check the details which have been provided. If the details are okay, then there's no issue you need to do at this stage. But if the details are not okay, then you have a period of 90 days within which to launch a complaint with the registrar at companies, at lands. So once the 90 days expire, then there'll be conversion of those registers and the titles to the new regime. So once they convert, that's when now the registrar will then issue another notice through the national circulating newspapers and the national radio, inviting parties to now bring the current titles and collect the new ones. So far, the process has only reached the process of publication of the conversion list. What they are working on is now the conversion of those titles, so that once they convert a specific number of titles, they invite parties to bring the initial titles and collect the new ones. So there's been a lot of heavy stakeholder engagement on this process because of the obvious concerns that arise in respect of this submission and change of titles, and also the nature in which land is a sensitive process in Kenya. So one of the outcomes of those discussions has been, and is in respect also to the timeline of operation, is that there should be no lag between the time period when you submit your current title to receive a new one, also as to incentivize the parties, because if you're told to just go and submit and come back for a while, a number of people will be hesitant to do that. But if you're told you're bringing your current title and collecting the new one, then that will give parties a bit of more confidence. So that's what they're working on, in trying to ensure that actually happens. So that in terms of also how they'll be calling parties, part of the discussions have been to ensure that they only call an unmanageable number of parties within a frequency which they're able to manage those parties. So another key thing to note, especially now that we are having a discussion which has been facilitated by a bank, is that if the current title is charged by a bank, it will be submitted by the bank and the new one collected by the bank, because this is now a security which the bank is holding, and it will not make sense for it to be returned to the owner, because it will break that chain of custody and likely prejudice the security which the bank is holding. However, there's some documentation which will need to be signed, and I know that's something which the bank is coordinating with the parties whose properties have already shown on the register. So pretty much that's the very general high-level overview of those two key conversion processes. So there's the digitization, there's the conversion process. If there are any questions, just hold on to the questions, so that also Caroline deals with the aspect of sectional properties, then we'll handle the questions. Thank you very much.
Thank you very much, Ruben. So as Ruben mentioned, I'll be taking you through the changes that are coming into play pursuant to the Sectional Properties Act. Ruben, maybe I can ask you to, thank you. So just for purposes of explanation, sectional properties are properties that are within a building where you have a building that has multiple units and you have different owners owning different parts of the same building. So a good example would be an apartment block where you have different owners owning different units within the same apartment block, and you have the same title because the apartment block sits on one parcel of land. So previously, what we had is that we had two regimes that were governing how sectional properties were titled. So the first regime was what we called the long-term leases. I think some of you, if you've had the benefit of purchasing either an office a space or an apartment, you might have come into contact with a long-term lease. So what would happen is that a developer would put up the building, and then the developer would issue leases to each of the owners. Usually the leases would be for a term of 99 years, where you had the underlying title being for a lesser term, then it would be for the remainder of the term. And then each individual owner would then have their lease registered against the title to the land. At that point, once all the units are sold, you would then have the developer transferring that underlying title to the management company, to a management company, and then issuing shares in the management company to all the owners in the apartment block. So that's the long-term lease regime, and it had been going on for quite a while. It is actually not based on any legal basis. It really doesn't, it's not anchored very well in law, but it did serve the purpose of transferring ownership, at least for that 99-year period. But come 1987, there was actually a Sectional Properties Act that was enacted, but very few people actually have any kind of contact with this act because it wasn't taken up by the market very well. And the reason for that is because, one, it was not compulsory for everyone who was, sorry, Ruben, maybe you can just go back. It was not compulsory for developers to use the Sectional Properties Act. And I think, like anything, when you bring in something that requires change, people will tend to normally stick with what they know. So the old system of the long-term leases continued, despite the fact that there was a new act in place. The second reason why the Sectional Properties Act 1987 was not picked up very well by developers is because it required all developers to convert their titles to what we called the RLA system of titling. If you remember what Ruben was taking you through, we have in Kenya, or we had previous to the year 2012, 5 to 6 different statutes that regulated titling. So what this Sectional Properties Act for 1987 required is that despite whatever titling regime you fell under, you needed to convert your title to the RLA system. And so a lot of developers were reluctant to do that. And so the act wasn't taken up by developers. The other requirement in the act that was a bit tricky for developers was that in the 1987 act, any deposit paid by a buyer could not be utilized by the developer to build the units. If you're familiar with how most developments are done, pre-sales are really one of the key ways in which developers are able to fund, their developments. So the fact that developers could not access these deposits meant that they were reluctant to then, convert their titles and issue sectional titles. They preferred to go under the long-term lease because then they had access to any deposits that the purchasers had paid. So what happened with the Sectional Properties Act 1987 is that it ended up being used mostly by government agencies. So if you've had the benefit of purchasing a property built by the National Housing Corporation, you probably have a Sectional Properties title under the 1987 Act. But in the private space, there are very, very few developers who picked up this act. So given the fact that we continued having the long-term leases, and given the fact that the Sectional Properties Act 1987 was not well adopted, the government came up with a newer, more refined version of the Sectional Properties Act, which was passed in 2020. And this Sectional Properties Act is actually compulsory for any person who owns a unit in a building, and for developers who have developed these units or are in the process of developing. And so as we go through the slides, you'll see some of the sections and how the conversion is supposed to happen. So Ruben, maybe we can move to the next slide. So the reasons why the new Sectional Properties Act, in our view, we feel was needed and has actually come in at the right time is that there was a lot of issues with the two systems that I discussed before. One of the issues that I wanted us to talk about is the issue of the reversionary interest. Now, the concept of a reversionary interest is something that is very difficult to even define as lawyers because it's not anchored anywhere in law. But basically what that means is that once you sell all the units in an apartment, the title, the underlying title on the land, that's what we call the reversionary interest. And normally what was supposed to happen is that this title was supposed to be transferred to the management company, and then all the homeowners have a share in the management company, and therefore they all own a piece of that reversionary interest. What had happened over time is that developers were actually not transferring these titles. In many agreements, you would see that the developer would say until they've sold all the units in the building, that's when they'll transfer the reversion. And so what developers would do sometimes is that they would keep 1 or 2 units and not sell them, and therefore not be required under the documents to transfer the reversionary interest. So you have a lot of owners, apartment owners, who do not have any share in the management company or do not own the reversionary interest on which their building sits on. Like I mentioned before, the lack of basis in law in terms of the long-term lease was also an issue that the government needed to come and close that loop. The other issue, like I mentioned, was the management company. You would find that in some of these apartment blocks, the developers would not issue the shares in the management company. And one of the ways they would do that is, again, by saying until they've sold all the units in the development, then they are not required to transfer the shares. And so what would happen is that they would, of course, withhold a couple of units and therefore continue to be in control of the management company. So the management company would be tasked in managing the whole building and in collecting things like service charge. And so when the management company is not owned by the owners, it's owned by a developer or a developer who's actually sold all the units and retained only one, what would happen is that the developer would then be in control of things like how much service charge to charge, whether they would actually manage the property properly. And so there were a lot of complaints from apartment owners that whatever had been promised was actually not being delivered. So we can move to the next slide. So the highlights of the new Sectional Properties Act 2020, and I'll take you through a few steps so that you can see how the act is supposed to work. So what would normally happen is that a developer would come up with a plan. Of course, the architects will draw up the plan. They would then take this plan, the building plans, to the county government, and they would get approvals on the plans. Once that's done, then a surveyor would have to come in. This would be a licensed surveyor by the government, who would then come in and prepare what we call a sectional plan. So the idea is that this sectional plan must be very detailed and must show each and every unit. And when I mean each and every unit, I mean the walls, the ceiling, the size of the units, so that each and every unit has a separate plan on its own. So that's what we're calling a sectional plan. This sectional plan is then taken to the lands office, and together with the underlying title to the land. And once this is submitted, the title on the underlying land is then closed, the registry, in respect of that underlying title, and separate registries are opened for each and every unit in the building, such that each and every unit would then have a separate plan and would have a separate title. Think of a deed plan when you're thinking about the sectional plan. You should be able to actually, in fact, the term we use is georeferencing. You should be able, even using Google Maps, to actually be able to map out that space in the building. If you're talking about an apartment on the 5th floor, it should be georeferenced to the specific coordinates. So that is something only a surveyor can do. And so a surveyor would actually have to prepare this for a developer. And the developer will then take that sectional plan for each and every one of the units that they've built and take it to the lands office and surrender their title and get separate titles for each and every unit. Those separate titles are the ones that will then be transferred. The other thing that would happen at the time of registering the sectional plan is that a corporation will then be put in place. This corporation is coming in to take the place of what was the management company. The corporation is not registered under the Companies Act. It is just a corporation under the Sectional Properties Act. And this is actually a needed change that needed to come in, because under the old system, the management company would have to comply with the requirements of the Companies Act. And most of the time, most unit owners were not very conversant with the Companies Act. So things like annual returns and things of that nature that have to be filed at the company's registry, you'd find a lot of management companies were not doing it. Because the corporation is not a trading entity, it therefore does not have to sit under the Companies Act. It's just a separate entity. And its role is to manage the apartment, or rather the building itself. So if you think about what management companies were required to do, things like insurance of the building, that would be the corporation that would do that. Anything to do with management, repairs, collection of service charge, collection of garbage, gardening, that would sit with the corporation. The corporation will have bylaws that will govern how it will run day-to-day activities. The homeowners can amend these bylaws as and when needed, but at the time of registration, if the developer does not have a set of bylaws, then there's a default set of bylaws under the Act. So if a developer doesn't want to actually, come up with new bylaws, they can just take what is in the Act, and it's very vanilla type of bylaws, but they work and they can use that. But the homeowners can, at a later date, amend that if they want to. I think one of the key welcome changes under the Sectional Properties Act is the concept of a unit factor. So what a unit factor means is that what is the share of each owner when it comes to the larger portion of the building. So for example, if you have 20 apartments, it means each unit is 1/20. So if you're talking about costs, it means that unit owner is required to pay costs that are 1/20 of the whole. If you're talking about any benefits that they're getting, then that's the unit factor we're talking about. The Sectional Properties Act also discusses the issue of common property, which under the old regime, we used to call them common areas. I don't know if you come across situations where sometimes you would be informed, maybe, this is an apartment block, there's going to be a swimming pool, there's going to be this and that, and then that doesn't happen. Or maybe a developer decides an area that was meant to be a playground they're going to use it, build an office or do something with that common area. So at least under the Sectional Properties Act, common property is well protected, because at the time of putting up the sectional plan or coming up to the sectional plan, the common parts are well defined, and these are protected and are controlled by the corporation itself. The Sectional Properties Act also discusses dispute resolution, which was something that was silent in the old regime. If there was a dispute between two property owners or the corporation and the property owners, there's now a dispute resolution mechanism that allows the parties to at least first have an alternative dispute resolution before going to court, which is very, very welcome. The other changes are that if you have a lease or if you have an underlying title that is for 21 years and above, then you are able to get, and you want to put up a building like an apartment or office block, then you can come under the Sectional Properties Act. The old Act required you to have at least 45 years under your underlying title. At least this period has been reduced considerably, and this is good, especially given the areas that have really been quite mushrooming with a lot of these apartments. If you look at the Westlands area, Parklands area, a lot of these leases don't have 45 years and above. Some of them are quite short. So at least now, even if you have a 21-year underlying title, you can put up an apartment block and get sectional titles for each unit. I think the biggest catch is the fact that there's a timeline for conversion of all units in Kenya that were registered under the old regimes. They all have to be converted within a 2-year period of the Sectional Properties Act coming into force. And that deadline is December of 2022. So this is what we want to highlight, that there's a conversion that is required and that this has to happen quite quickly. So we can move on to the next slide. This is a quick overview for any new developer, and I think for banks, this is something that you would probably be interested in, because you would be, you would be financing some of the developers who are putting up apartments. These are the documents that are required by a developer for them to be able to get titles under the Sectional Properties Act or to sell a unit that falls under the Sectional Properties Act. They would have to have a purchase agreement. They would have to come up with their bylaws. The good thing is that there is a set of bylaws in the regulations. If they're not able to prepare one themselves, they can just adopt that. They would then have to get a certificate of title for that unit before selling. That can only happen with them having actually gotten a sectional plan. If there's any management plan, they would have to put that in place. And if there's any charge under the underlying title, that would also have to be surrendered to the land, presented to the lands office for them to be able to get the sectional certificates and for them to be able to sell the units. So moving on. So this again deals with the developers. For the underlying charge, where you have a developer who's borrowed to actually put up a building that is going to be under the Sectional Properties Act, they need to disclose the charge, the maximum principal amount, the maximum monthly installment, the amortization period, the term of the loan, the rate of interest, and the prepayment privileges. All this information would normally be provided for in a charge anyway, but it's good to just remind ourselves that these are the key commercial terms that have to be set out in a charge and that have to be disclosed to any purchaser who is buying into a sectional property. So the conversion process is set out in Section 13 of the Sectional Properties Act. So the conversion process can be initiated either by the owner of a unit, either by the management company, or either by the bank, which is the chargee. So we are talking about conversion. These are properties that have already been sold under the long-term lease regime that are now being required to be converted by December of 2022. So either one of those three can start the conversion process, can initiate the conversion process. As I mentioned, the conversion process has a 2-year window, which expires in December 2022. So if the owner of the management company or the bank decides to do this, then they would have to submit a sectional plan, like I mentioned. They would have to submit the long-term lease that is being converted. They would then have to also submit the original main title to the underlying land. Now, there's a chance that this title might not be available because maybe it's with a developer. So what the Act allows is an indemnity, for you to provide an indemnity, similar to what would have been provided if, let's say, the title had been lost. So you would provide an indemnity, and then this would the registry will then gazette for 60 days, and once the gazettement period expires, they would then proceed to issue with a sectional property title. So I think it's good to see that it's not just the developer who has the power to commence this process. Even a unit owner can do it, and even a bank can do it, just to make sure that you comply with the Act and you're not out of time. So the regulations come in and they expound a little bit more on how the conversion process is supposed to happen. There's a form called Form ST16. It's at the back of the Act. That's the form that you would fill out for you to be able to then commence the conversion process. The regulations repeat a lot of what is already in the Act. The fact that you have to have the plan, you have to have the lease, you have to have the underlying title. And so that is already discussed in the regulations as well as in the Act again. The interesting thing to note is that there are some developments that have been exempted from this requirement. And the first one is where if there was a development where the reversionary interest was to remain with the developer, and this had been expressly stated in the agreements and in the leases, then that type of development does not require conversion. Large mixed-use developments and phased developments will also not require conversion. A good example would be, let's say, something like Two Rivers or Garden City, where you have a mall, and then the next phase you're going to have apartments, the next phase you're going to have maisonettes, and they're all sitting under one title. The Act says that those types of developments are exempted. And then projects of strategic national importance have also been exempted, and SEZs. So a development like Konza City would be exempt. A development like Tatu City that has already gotten its SEZ status would be exempted. So just moving forward, some of the positives that we see with the coming in of this Act is that the intention is to really push forward the Big Four agenda when it comes to housing, especially affordable housing, which can only be achieved through, development of mass units in small spaces and trying to go as high as possible when it comes to the build. So ensuring that individuals are able to get titles, because especially at a certain level of sophistication, when you give somebody a long-term lease, some people just don't feel that that's a title. So the fact that people can actually own a document that's called a title and it's been granted by the Lands Registry is a positive move. It just makes the transactions much easier when you're trying to explain to people that yes, you do own a piece of a building. So it really was pushed forward once the Big Four agenda was tabled. The rights of owners in buildings have now been determined and registered, and they're now secure, especially when it comes to the whole issue of the reversionary interest. I think this is the part that has actually been cleared up, and the issue of the management company and how owners are supposed to participate in the management of their buildings. This has come out very clearly in this new Act, and it's a welcome change. And like I mentioned, the corporation is a special management vehicle that sits outside the Companies Act. So all these extraneous requirements under the Companies Act will not strain the management of the corporation, which is good. The payments of rent and rates, I think this is an important one to note. Under the old regime, the rates and rent never really changed because the underlying title remained the same. So normally what you would find is that a developer would put up an apartment block, and whatever rates or rent they were paying, they would just divide it by the number of units. But now, with each owner having their own title, each owner is actually going to be charged their own rent and their own rates, which means this is an added revenue collection vehicle for government and for counties who can now, charge. I guess they would be the ones who are benefiting the most. They can actually charge separate rates, which is what they will actually do for each and every unit. And then independent titles and closure of the mother title stopped any further dealings in the mother title. What I mean by that is that in some instances, you would find that an apartment block has been put up, leases have been registered, and then a developer or somebody, who's up to no good would then take that underlying title and try to sell it or even try to charge it to a bank, yet there's an apartment block that sits there. So the fact that now this underlying title will actually be destroyed and that register will actually be cancelled and each unit will get its own title means that the owners are more secure in terms of what happens to that underlying title. Because many times if you ask even anyone buying into an apartment what happened to the underlying title, they don't know. They don't know where that title sits. Is it with the developer? Is it with the management company? So at least knowing that that would be destroyed and all the only titles that will be available are the unit titles means that your ownership is a bit more secure, which is good. And then the issue of the unit factor, which is what I mentioned, being able to actually apportion what does each unit owe when it comes to service charge, when it comes to a percentage of the costs that for running the development. That is something that is now defined at the time of registering the sectional plans. So a few challenges that we see between now and December of 2022 is definitely that the conversion process will really be a massive process. You can imagine all apartment blocks, all office blocks that were sold before 2020 have to be converted and given sectional titles. So we see this as something that will be quite time consuming. And from a procedural point of view, it's something that has to be tested for us to see how quickly will the registry be, how efficient will they be in getting this done. Enforcement of charges that have not yet been converted post 2022, this is a big question mark that all of us are trying to wrap our heads around. If the banks don't move quickly and they're sitting on titles that are not converted post 2022, how does that affect their ability to, to enforce their security? One welcome change under the regulations is that it says at the time of enforcing this security, a new title will be issued. But what is not clear is whether that can only happen before 2022 or it can also happen after 2022. We need clarity on that from the government. For finance developers, this is a situation where a developer is borrowing to put up units, where the leases had already been prepared. And anybody who's done, conveyancing of developments, you know that it takes a very long time, between the time you break ground, you get your agreements and the leases. You have some developers who are in a situation where they have signed leases currently. They don't know what to do. Do they go ahead and register these leases? Do they go back and now prepare a sectional plan and get new titles and then go back and give these titles to the owners? So we are in that transitionary period where you realize that there are developers who are sitting on titles who don't know what to do, at least the long-term leases. And this can really be a problem because it means that your cash is held back. Because a lot of times that last bullet payment is made once registration happens. So if you're a developer and you have leases, we have developments like that where we're sitting on leases and now we know if we have to go back and do a conversion process, it could take us months before we have access to this money, and that's not a good position for a developer to be in. And then for mortgage applications for unit owners with leases that are yet to be converted, this is also an issue. I know there are some people who are in the process of buying apartments. They already had approvals from their banks, and now they have to wait a little bit longer for this conversion process to happen. And the last thing that I wanted to discuss is that if you place a restriction on the title, it's equal to punishment to the owners and the financiers. So this is something that we have been discussing with the registry, that they need to have some kind of transitionary period, because at the moment, stating that they will only handle sectional properties or sectional titles means that anybody who's holding a long-term lease and was just about to register, was just about to get to draw down on their loan, is now having to wait for a considerable period of time before they get they are able to get a title to their property, get the charge registered, and then get the monies out. So this is something we are discussing with them, and we are yet to see where this will take us. So thank you so much. We will now take your questions. I think we can take them concurrently. Ruben?
Thank you, Caroline and Ruben. We have some of the questions. I'll just read them through, or if you'd like to go ahead, sure. So the first one is from Jasmeet. She's asking, how long does the verification process take at the lands registry once all the details have been entered online?
Thank you for that question. So so far they haven't established specific timelines. However, where the property has all the details in order, the verification is happening as soon as possible. Where we are seeing a challenge is in cases where there are some issues with the documentation on the title. So those are the ones which we are seeing a bit of an issue, but they haven't clarified that timeline. So there has been discussions which were ongoing towards the end of last year, where the ministry had actually confirmed that they were going to issue timelines. They haven't issued those timelines yet, but from experience, what we are seeing is where there are no issues, the verification is happening in a relatively fast period of time. But then in a case where there are issues to be resolved, that's taking a bit of a while, but they're yet to confirm those timelines. As soon as they do, I guess, communicate to the bank.
Thank you, Ribin. The next one is from Rachel Kamau. Do you require the assistance of an advocate to register on Aarti SASA platform?
No. You just log on to the system and just register the details, and the prompts are pretty easy and straightforward. Yeah, so you just follow the prompts and register. Okay.
Bobby Kola is asking, will you be able to kindly circulate your slide deck?
Absolutely. Javed will share. We've actually shared this with you. I guess now you will circulate it from your end.
Will do so. Thank you. Mr. Manish Parmar is asking, are owners notified once title is listed in digital platform, or do owners need to check on their own accord so that they are not time banned on the 90-day period?
So that 90-day period, that's on the conversion process. So that's actually the notification on that gazettement of those notices. So the owners actually need to be checking the gazette notices. But the good thing is that after a number of review of the processes, now they've started also indicating the areas which they've gazetted. So it's quite easy for someone to run through the gazette notice if you see your area has not been listed and confirm whether you need to check it keenly. If you see your area has been listed, then you'd have to check keenly to see your property, how it's been listed there. So that's the notification by gazetting, which would then mean within this period, then parties have to be really keen in terms of checking those gazette notices, or give instructions either to their advocates or someone to be checking for them.
Okay. Also, Jay Ladder asks, what happens if the discrepancies between what you've entered and what it is supposed to be verified against is not resolved within 90 days?
So those are two separate processes, because there's that verification under the digitized system, and there's the conversion for the 90 days where the titles are being converted into a consolidated regime. So the verification under the digitized system, what happens with that is once they check and confirm that the details you've entered are varying with the details on their end, then there's a mechanism for which there can be feedback on what the issue is, and if it's an issue of an error in terms of the entry, the application the correction can be done. That's on the other side. On this other aspect, in terms of the 90 days, the information which they are gazetting for the 90 days is what they have in their survey records. That's what they are gazetting, because they are redoing the maps afresh with the information they have. Now, based on that information, they gazette that for the public to view. So when you view the details, if those details then are corresponding with what you have, then you're okay. If the details are not corresponding with what you have, then you have the 90 days to raise that issue to have that sorted. So there needs to be that distinction between that period where there's the gazettement of the 90 days, which is for the conversion process, and there's this other process now where you're verifying under the Aarti SASA digitized process.
Okay, Mr. Manish is also asking if Sectional Property Act also applies to villas and townhouses under single title.
Caroline?
Yes, they do. Provided there was a requirement for the reversionary interest to be transferred to a management company and all the units are sitting on one title, then you would get a sectional properties title for each and every one of the units.
Thank you. Anil asks, what happens to the management companies registered before? Do we have to change to a corporation under the new Sectional Properties Act?
Yes, so what would happen is that you will transfer all your assets out of the management company, all liabilities will move to the corporation and the management company will be dissolved.
Okay, thank you. There's a question from Austin Baraza. Will these changes affect ancestral land or community land?
The reforms, the way we've discussed, are actually affecting all properties based on now the respective aspect, like the way we've talked about the digitization aspect. So right now, all the properties which fall within the Nairobi Block Registry, regardless of the type of property that they are, the owners or the registered parties have to actually apply for them to be verified, for them to be dealt with. In respect to the conversion of the titles under the single consolidated sort of title, again, based on how they keep preparing the cadastral map and they move across the country, they'll apply to every property based on those particular times. So it's being done in phases, but eventually it will apply to all sorts of properties. The only difference would be in terms of the sectional properties, which will only apply to the properties as Caroline has explained.
Right, just a few more questions. Mary Nerima asks, do we need to pay both the land rent and rates for 2021 on Ardhi-SASA, or can we do it on eCitizen? And when is the deadline for the conversion?
So right now, land transactions are not being carried out on eCitizen. Everything is being done on Ardhi-SASA. In fact, I think even that platform on eCitizen has been closed fully. So all land-related aspects online, the only platform which is processing land-related transaction is the Ardhi-SASA platform.
Okay. Avin J asks, where can we access the gazetted notices?
So the gazetted notices are usually published on the Kenya Law website in terms of the digital version. Also, the hard copies are usually found at the Kenya Gazette, the Kenya Gazetting offices. But I guess the online version would be easier because the Kenya Law page has a section there for gazettes that have been published, and that's where they can be accessed. And generally, they've been circulating because there's a lot of interest on it once they've been published. They've been circulating perhaps in order to add value. After this, we can have a discussion with Javed how we circulate. We share with Javed the ones that have already been published, so that as they are circulating the presentation, they also circulate the notices that have already been published to make it easier, at least to check those ones.
Sure, we can look into that for sure. Also, Ribin, we have another question from Steve. Kindly advise on alien ID property owners on creating Ardhi-SASA account. That is, I'm getting response that the first name does not match with what is in the registry. What's the way forward?
So once there's such a discrepancy, there's a chat box that appears on the right hand side of the screen. You just raise the issue over there. Then once you raise the issue, the registry will raise a ticket where you'll be allowed to upload your details. Once you upload your details, they'll give you a ticket for the resolution of that issue. Now, once you have the resolution, the ticket is more of like an appointment, which then you'll be allowed to submit the documents for them to verify and let you know what other additional documentation they'll need to see if they're satisfied by the documentation you have is in order for the information to be updated. So for now, just raise the issue on that. On the right-hand side, there's a chat box there. They are still working 24 hours on dealing with that one because they committed staff to work with that, because at this initiation stage, there are a number of issues. Then someone will respond and a ticket will be raised.
Just the last two questions, but I think one of which you've already just addressed. Peter Mtua is asking, does this mean that all the details on eCitizen under the Ministry of Land will not be accessible?
Practically, I'll have to check to see if eCitizen is still allowing parties to check those details. I haven't checked, but what I know is that now from the lands registry end, they are no longer dealing with transactions from the eCitizen platform. They've fully moved. They're only processing transactions from the Artisasa and LIMS platform.
Right. The last question, Anil is asking, well, a few more. So Anil is asking, what is the approximate legal cost of changing the long-term leases to sectional properties?
So they haven't prescribed a fee under the regulations. Ribin, are you aware of what they're charging? Because they haven't prescribed any cost yet.
No, there's no statutory cost. The only cost now, that cost of the surveyor to prepare the sectional plans and all that. However, for the 2-year period, as Caroline explained, the government is catering for that cost of that conversion. But once the 2-year period expires, that surveyor cost and any other cost now will have to be incurred on your own. It's part of that incentive which the government is using to try and incentivize parties to convert before the deadline.
Javed, were there some more questions?
Sorry, yes, just 2 more. Punit Shah is asking, do you have any idea how long for the ticket to be actioned on? I have one open since 10th of January, or is it 1st of October? But to date, they have not responded.
Again, no timelines have been set out. All we are aware from those stakeholder engagements is that they are sure that they've committed sufficient staff to deal with those particular issues. Perhaps the other resolution will be just following up from the chat box, because then someone would have to give you a timeline, just following up and request for a specific timeline. But then now that has been noted, I think in the next stakeholder engagement, while the push for the timelines for verification is being done, we can also present that as one of the issues which parties would like specific timelines on.
Okay, we have, I think, a hand raised from Mr. Rajesh Rugani. I'll just unmute him so he can ask the question. Yes, Mr. Rugani.
Javed, I think he's still muted.
Yeah, just a second. Mr. Rugani, you can now unmute your mic and ask your question.
Am I unmuted now?
Yes, you are. Please go ahead.
Okay. Thank you very much for that, Javed. Ribin, I would like to ask 2 questions, please. One is regarding unit factors. Supposing there is a building where there is a 4-bedroom, there are 4-bedroom units as well as 2-bedroom units, or a building which has the top floor where you have larger units, would the contribution be based on some kind of an actual accounting where larger units pay more, and would there be flexibility in the percentage contribution? So that's the first question. Would you like me to ask the second question as well? Hello.
Just ask both, though this one for unit factor, let Caroline answer that one.
Okay. The second one was, because of all these new developments, would it help a buyer who wants to buy a unit in a development where the developer is selling units which are under construction? And if we assume that the developer has done a good job regarding sectional titles, would it change the ability of a buyer to borrow from a bank whilst the property is under construction? At the moment, buyers only buyers who can raise equity for regular payments during construction get preference to buy from developers. That's my second question.
All right, thanks. Caroline, you want to take this one?
Yes, so the unit factor is determined by, at the time the building is being built, it can be based on square footage, or it can just be based on the number of units. So the law does not prescribe which direction you take, but the developer would, at the time of setting up putting up the sectional plan, decide whether it's one man, one vote. You know, so just if there are 20 units, irrespective of size, then you're each getting a share in the management, the corporation, and we're dividing the cost equally. But what I've seen when it comes to square footage, a lot of times office spaces will use a square footage formula. And and then for apartment blocks, normally you will have just one man, one vote, because irrespective of whether you have the penthouse and it's 2 levels or not, it's still one family that is using the unit. So in most instances for apartments, you'll just see a very simple formula where it's just one unit, one unit factor. But in office blocks, you do tend to have the square footage formula being used, so that if you have a larger space, maybe on your ground floor, then that unit would have a higher unit factor. So, and it goes 2 ways. If you have a higher unit factor, it means you're paying more and you're contributing more, let's say to your service charge and things like that. But it also means you have higher voting rights within the corporation. So there is some fairness either way, either direction you take. I hope I've answered that question.
Thank you very much. Yes.
Okay. I think your second question had to do with you're a buyer in a building block, and you're approaching a bank to get a mortgage. And we are assuming that the developer has done everything that's required in the Sectional Properties Act. Was your question whether there would be a delay in getting the financing?
No, maybe I don't understand the current situation. What I was trying to say was, my opinion was that currently buyers are not able to get financing for sectional titles. But would this open the floodgates for the ability of new buyers to borrow, which they didn't have before?
I think the regime that was in place before, the long-term lease regime, was quite familiar with banks. I know they were quite happy to lend against long-term leases. The leases were bankable, because they were usually for a term of more than 21 years. And so banks were quite happy to lend against long-term leases. I think the problem that we have right now is you might have a situation where you are borrowing, you already have your approvals in place, the building has come up, you have just signed your lease, and now the registry is saying convert all these titles. So you're now looking at another maybe 8-9 months, because nobody knows how long this process will take, because now your developer has to go back and prepare a sectional plan and go through that whole process. So if you were in the process of buying an apartment or something like that, you might be looking at a longer wait period. And in my experience, I've seen that many times when people are buying homes, they're really eager to move in because you're paying rent on one side. Maybe you've already moved your kids to a school near where you were buying your unit, and now you're having to wait much longer because the lease that you have is no longer a title. You were just about to lodge it at the registry. That's the scenario we were trying to discuss. That delay, unfortunately, a number of people will be caught up in that delay.
Understood.
Thank you.
Thank you very much. Yes, you have answered that question as well, because I think you're raising the difference between the time period between this changeover and what it can affect a buyer and a lender. So thank you for answering that. If I may, at this point in time, I would like to thank you very much for a very simple and amazing contribution to our knowledge. Thank you very much for that. I think on behalf of everyone who is attending, thank you.
Thank you so much, Mr. Rogani. Mr. Manish, you've also raised your hand, so you can go ahead.
Sure, thank you. Thank you, Javed. I'm asking probably the same or similar question what Mr. Rajesh was asking, but in a different way. What Mr. Rajesh is also kind of asking is there any protection mechanism for people who buy apartments on a pre-sale? So previously there was no protection mechanism. Does this new law bring in any change where people who buy on pre-sale are kind of protected?
Thank you, Manish.
Now I understand what you mean. So, example like the Suraya situation that was there, people have paid deposits and the building never comes up, something like that. Unfortunately, this act does not offer that protection. The 1987 one did, because it required developers not to use deposits to use for the build. So normally what would happen is that you would pay a deposit and it would sit in an account that the developer could not touch. That requirement has been removed. And I think the reason why it was removed is that there was a lot of pushback in the market that just practically it is very difficult not to use pre-sales as a form of funding for developers. And so, unfortunately, that protection, I think there was a lot of lobbying. It was removed. It was there in the 87 Act, but it's not there in the 2021. So it's the same old process where you would have an agreement, and whether you're paying milestones or whether you're paying a large deposit and then a small deposit and a larger sum at the end, those funds are not protected under the Act. So you would have to do that by private contract, maybe having some kind of contractual arrangement, but the statute leaves it to the parties to agree.
Noted, thanks.
Thank you. Just for matters of saving time and all, we have just last two questions. We have Jasmeet asking for land property owners in diaspora. Do they have a specific deadline for registration online? And Mary Nerima is asking, if you had purchased land and it's still on the seller's name, how long does it take to change it to your name? So the last two questions, we should wind up then the question and answer session. Yes, Rimin.
So there's no deadline for registration online, though it's encouraged for parties to register as soon as possible, because then you want, first of all, your details to be there and to be able to start using the system. Number two, if you have any property within the Nairobi block registry, you want to start applying as early as possible for verification, so that by any time you either want to transact on that property by taking a facility or selling it, because most of the time you realize when those transactions are coming up, it's usually there's an urgent situation to move fast. So you want everything is done properly, the property is verified, so that if at any point you want to transact, you'd be able to transact on it. So that's the question for Jasmeet. No deadline, but it's critical that you do it as soon as now. Number two, if you have purchased land and it's still on the seller's name, how long does it take to change your name? I mean, this still is the usual process, because if you had purchased land and it's still in the seller's name, it means the transfer has not actually been effected, and legally you are not the owner of that property. So the actual transfer process has to be followed. So unfortunately, if that property is still under the Nairobi block registry, the initial owner actually is the one who would have to apply for it to be verified, then for the transfer to happen, the application to be made and the transfer to be made. If it's not within the Nairobi block registry, it follows the usual process, just have the transfer valued, pay stamp duty and lodge them for registration. So they other than the Nairobi Block Registry, the other registries are still ongoing within the usual timeline. The Nairobi Block Registry, where the issue could be, is with the verification, but once the verification is done, the transactions are moving quite fast after that. So it's hard to give us specific timelines, but generally that's how that would go.
Thank you so much, Ribin and Caroline, for your wonderful insights into this topic for today. I would now like to invite Ruth Marcia to give a vote of thanks and close the session. Ruth.
Thank you very much, Javed. To our esteemed guests, clients, management of VCB, including the board members, I just want to take this opportunity to say a great thank you and good morning. I wish to thank you for all of you having taken your valued time to be with us today, just to be part of this process. I can assure you, you're among the first people to have received such kind of an intensive discussion from the best. We just want to thank you, Ribin and Caroline, for this engaging and quite informative presentation that you've made. What Ribin and Caroline have not told you is they spend actually almost half their daily time at the ministry trying to be part of this teething process. Ribin is actually quite involved in the testing of this platform. He works together with the cabinet secretary as well as the other stakeholders who are trying to ensure that this process is a success. So considering all the busy schedule that he has, and he still has given us of his time, we just want to say thank you. Thank you also, Caroline, for taking us through the process of the sectional properties, which I know is quite a tedious process, considering that the laws and procedures are not yet clear on what is supposed to be done. We just want to thank you for just going against the norm of saying we will have to wait until everything is clean so that we can present. We just want to say thank you. To our customers, thank you very much for entrusting us as your bank to be the ones to take you through this process, to enlighten you, and also to have your properties. I know it is quite a sensitive matter, but as a bank, we want to undertake that we will try as much as possible process pretty easy for you, and we can guarantee that with the best team and the best lawyers, as you've seen, we've chosen the best just to make sure that the process is going to be smooth for you and for everyone who is involved in it. I also just want to thank you, Javed and the rest of the VCB team who've taken a lot of their time to make sure that today is a success. I just want to extend my gratitude to you, including also the VCB IT team for just ensuring that we've had a seamless session. I want to close by thanking the VCB management for allowing us as the legal department and as the legal stakeholders to take this opportunity just to take our clients through this session and for entrusting us with such a sensitive matter. Thank you, everyone. I know quite a number of us have been involved in this, so if I've not mentioned your name, I just want you to know that we are grateful for everything that you've done for us. Thank you, our clients. We wish you a fruitful year ahead, and we promise that we are going to be part and parcel of this process for you, so you can entrust us with the hard challenges that this process has, and we guarantee that we will ensure that it's a small transition for all of us. Thank you, and God bless you all.
Thank you so much, Ruth. Thank you also to the legal team, including Rachel Kama, who has really helped facilitate and coordinate this wonderful webinar. Once again, thank you, everyone. We shall see you again in our next webinar. Have a good weekend.